Oops, I touched the screen by accident. Peace, everyone. We are live. What's today? Saturday?
Yes, I believe so. Yeah.
Um, we will be talking about foreclosures today. I have my perfect wife with me to assist. I'm trying to find it so I can watch. Let me make sure it's in mode so I can ensure that the things are showing how it's supposed to. Peace. Okay, that's the live version. All right, here it is. Cool. All right, we are live. There it is. We're gonna jump straight into it. I mean, no need to lollygag. That's not what I meant to do. Let's do that. Let's do this. Let's move that there. Let's do this. And I think that should be it. All right. I think we can zoom in. Do this. Oh, that's how that happens. Okay, that's fine. All right. So there's been a lot of inquiries about this topic. So we're just going to talk about it. First, I want to talk about what a foreclosure is. A foreclosure is supposed to be what happens before you sign a contract. So the signing of any contract is called a closure. So let's say, I know I talked about this before. I'm looking at the screen, but you're right here, so it's weirdly positioned. The camera's right there, so it's weird. So we talked about this before. That like let's say you owe me $100 and you can't pay it up front, so we would negotiate whether a payment plan or whatever we would negotiate. And if I don't like how negotiations are going, what am I saying? If I don't like how negotiations are going, I can say, you know what? Instead of negotiating with you, I want all of my money right now. So before the closure, I want all of my money. That's why it's called a foreclosure. Um, the closure of anything is when you sign something, which means the terms, conditions, and obligations of the contract are no longer up for negotiation, and we both agree that we're going to do X, Y, and Z. So that's a foreclosure. So when creditors are foreclosing on people after the closure of an agreement, that is illogical because you can't do something before something after it already happened.
Mm-hmm.
That's number one. What they claim in court, and I'm going to read an example. Someone just sent this to me. I'm not going to read all the personal information. I'm just going to read some of the brief things that it says. And it starts off with blank mortgage LLC versus the person in the superior court of that place. And it says the defendant enters a denial to plaintiff statement.
Screenshot it so you don't have to keep doing that.
Uh, the defendant so and so being indebted to the bank executed on obligation, and then it says in quotations the note of the date to secure a sum of X amount of money with the initial interest of blank percent per annum on the unpaid balance. Said note being payable in monthly installments of principal and interest in the amount of blank, beginning on the date and subsequent installments of principal and interest per month thereafter until another date, which is about 30 years later. So they're saying that we are alleging that this person entered into a promise. That's what's called a promissory note. Uh, and we loaned them X amount of money. And they promised to make monthly installments plus interest of this amount of money. They failed. So since they failed to pay that, which they often call a default, which is also called a breach of duty or breach of contract. You broke the contract by not paying. The bank is alleging that you broke the contract by not paying that amount of money that you agreed to pay. And since you, when entering into this promissory note, put up your house as collateral, which is the mortgage, that's called securitizing the loan or securitizing the debt, we want your house in exchange. And they entered all these documents as proof that they're a plaintiff or proof that they're the holder in due course of this promissory note and that they are the creditor because they loaned you something. So they're taking the position that they loaned you something and they're claiming that you promised to pay them and that you didn't. Or you paid them a certain amount but not the full amount. Right? So people are often, they don't know what to do, they don't know what to say, and it's understandable because we're not taught anything in school, right? So as the big sign says, this is not legal advice. Let's just zoom in for that. Right, so it's not legal advice.
That should be the photo choice for the thing. They don't let you do that anymore, huh?
What, make it a thumbnail?
Yeah, when we went live the other day, it didn't have a option for thumbnail.
I put a foreclosure thing as the thumbnail. One of the things, I'm not sure if it pops up. Does that pop up? Oh, this is all butchered. Okay, it wasn't like this before, but that's fine. So the reason why the screen is changing is because I have another Word document up. And the two documents that I'll be going through are, can you hear me that? The foreclosure thing. And there should be another one under it, the financial literacy. These two documents, this one, and this one, I'll just be copy and pasting the res judicata that's in it. So the nature of it is a creditor is claiming that you owe them something. So there is a federal law. This is very difficult to do. There's a federal law known as the Fair Debt Collection Act. And let me see if I can find it real fast so I can copy and paste it. Should be able to see that, right? This is the law. Fair Debt Collection Practices Act. 15 USC subsection 1692G. That's the federal law. And in this federal law, it basically says that creditors have to validate the debt. The creditors have to prove that this debt is real. Prove that they actually loaned something. Because if they don't prove that the debt is real, then anybody can just claim anything and defraud people out of money. But what's very important to understand is that when the bank enters into the promissory agreement, they promise to loan you money. Let me go to this other case right here because I'm going to just copy and paste it into the document. So there's a case, Remington Investments versus Hamedani. Not sure if I'm saying that correct. but I'm going to copy and paste it. This is from one of the books that I have available online on my website.
Didn't put the title.
No, I know. That was just, instead of putting it after every single little paragraph, I just put it above and below. It was really just for me.
No, I'm saying when you oh, okay. I was saying when you pasted it, the name doesn't come up. So if like somebody wants to look it up.
Oh, well, I mean, that's why. It's at the bottom.
Oh, yeah.
But that's also why I put it in the book so people can look it up. But I'll read it. This is all from the case. Let me do this. I'll read some of it. I'll read all of it. It's not that long. But we're putting it in here because it's going to be case law that we would use in response to the little example I just read. So this is from the court. This is all from the court. So I'll do it like this. Boom. So you can see this is a quote from the court. But I'm putting it not italic so you can see. Hold on, let me make my camera smaller. All right, so it says normally a promissory note is given to a lender contemporaneously. See, that's why you're here. With the borrower's receipt of the face amount of the note. Now, I don't know anybody with a mortgage that has also gotten a receipt that says, like when you go to the bank and you withdraw money, they give you a receipt. It says Citizens Bank, account balance, $5, withdrawn, $2, date, this date. Sometimes they'll even have a teller's number that's associated with a human being that works at the bank. So that way the bank can say, yes, we can validate that this was an actual withdrawal from this account on this date by this bank teller. So that's something to keep in mind as you're preparing this straw man argument against this straw man bank that doesn't exist. This is just a trial.
It also says it's given to the lender, not the borrower.
Yeah, so a promissory note given to a lender. So let's say you're the lender. Let's say you're the bank, and I'm borrowing $500 from you, right? With my promise to pay you, you would give me a receipt. That's what that's saying. So if you're the bank, I'm getting a mortgage, I'm getting a loan from you. With the promissory note would be my receipt that I received money. Good.
So I'm confused because it says that it's given to the lender.
No, look. So a promissory note is given to a lender with the borrower's receipt of the face of the amount. So it's a receipt. So you would get a receipt.
To the lender.
Yeah, but you would also have a
borrower.
receipt because you get a copy of everything.
Yeah.
You know what I'm saying? That's my point. You would get a receipt. Just like the bank also has the receipt of the amount of money you took out, you have the receipt. That it's printed from the lender.
Yeah.
You know what I'm saying? So they would have to prove that they gave you something. Part of the note. So part of your promise is proof that they gave you something. Normally. So why isn't this happening?
That was my confusion.
Right? When a promissory note is paid, the note is normally canceled. The burden then shifts to the borrower, meaning you, to rebut the presumption either by proving payment or by proving that the face amount of the note was never advanced. What does that mean? So that means the bank is claiming that they made a promissory note. So now, since they're making the claim, the burden shifts on you, the borrower, to rebut the presumption. Right? So you're rebutting the claim that you failed to make a payment by proving payment, number one, or, which most people don't even consider, by proving that the face amount of the note was never advanced. That is a complex way of saying, or proving that they never gave you the money.
They never fronted it.
They don't have the borrower's receipt. You never received anything. So how could I pay you if I never received anything? Right? The agreement to repay reflected on the document headed promissory note is not an unconditional agreement to repay a sum of certain money. So it's not unconditional. It's based on conditions. The primary condition is that you actually loaned me something, right? Instead, it is only a conditional agreement to repay whatever sum might periodically be advanced. This is not complicated. Not. Did you graduate college? Did you spend any time in college? How many years?
At least 3.
I spent 0 time in college. In fact, 7 days after I graduated high school, I joined the United States Marine Corps, which requires the lowest ASVAB score for any military branch. So by no means am I super duper intelligent. I graduated high school 2010 and did not seek any further advanced higher education.
That doesn't mean you're not intelligent.
I can comprehend, but basic high school public education plus more military indoctrination, and I can understand this. And I'm saying that because our people need to learn to trust their ability to understand things that are written like this because they doubt themselves.
Yeah.
Right? So I don't have any more education than you. Matter of fact, the viewers probably have more education than me. The mere existence of this line of credit agreement does not support a presumption that the full amount of the line was ever advanced. So just because they have a piece of paper that says promissory note on it with a number typed on it does not mean that you actually received anything. This is a court saying this. A judge is saying this, not me. A judge.
Sorry, I was just going to say, and if they're not giving you the money and they also can't own the home because banks can't own things like that, what are they really giving you?
They're and this is, we'll get to that later. What they're doing is called promissory fraud, and we'll read some of the definitions that I have in these books, that I have prepared for people in these books to show you that the fraud is you believing that you're getting something from them. Right. That's the fraud. And then you actually pay them money and they don't give you anything. That's the fraud. The note document itself is not a business record, as that term is used in the law of hearsay, but rather is an operative contractual document admissible merely upon adequate evidence of authenticity, which means what? Validation of the debt. So it in and of itself is not proof. You have to prove that money was lent. This is what this judge is saying. Res judicata.
Yeah, because it's not like every month.
This is the highest court.
Every month when you go to pay your mortgage, you're paying out of your pocket, not money that was loaned to you.
Exactly. You never paid anything that was loaned to you because you never received a loan. You never received a loan. Ever. And there's no receipt of it. Right? So the promissory note itself is an operative document admissible only upon adequate evidence of authenticity. I mean, they have to prove that this is real, part of which is having the borrower's receipt. That the borrower, probably you, received anything. So show me from, since you're a bank, most of these mortgage companies have a bank account. Most LLCs have their own bank account. So show me the transfer, just like if I transfer you money on Zelle, I can go to my bank and it's going to say, from this account to that account on this date, this amount. And whatever little friendly note, I love you, my dear wife, on it. That's proof. So, why doesn't the bank do that? Ever. Right? So, and we'll get into that shortly after this. The promissory note in isolation did not show what amounts were advanced pursuant to the line of credit, what amounts were repaid, when what interest had occurred, etc. Accrued, excuse me. The promissory note in isolation did not show what amounts were advanced. It shows an amount that was promised to be lent, but it does not show how much of that amount was actually lent, was actually given. So If the bank says, this promissory note is in the amount of $200,000. Did they give you it in $2 increments? Did they give it to you in $3,000 increments? Did they give it to you in $10,000 increments? And then where's proof of that transfer? As an example, this foundation that I'm part of, we just won a grant for a mural project to put up art downtown. The company that's the nonprofit that's giving us the grant money is willing to give half of it up front. So there's a full amount that is being given. It's a grant, so it doesn't have to be paid back. There's no interest. And they're giving it in increments. And that there's going to be a transfer from their account to our nonprofit's bank account because we had to open one in order to receive the money. Mm-hmm. So there's going to be an actual transfer. It's not complicated. Right? So that's the opening to the financial literacy book. That is the first set of res judicata that is available in that book. I feel like this isn't... Okay, yeah, that's there. And this is from this right here. Also copy this. Any questions so far, Juju? Or anything you would like to add?
No, not at the moment.
This is also in the book. This is a quote from Cornell.edu defining what a loan is. A loan is a form of debt where one party agrees to lend money to another. While generally synonymous with debt, debt covers any amount owed to another, whereas a loan refers specifically to an agreement where one party lends to another. Loans and debt generally share the same characteristics, meaning what? Somebody gave something to someone else, and somebody received that thing from someone else. They are composed of principal and interest. Principal means the amount that's being lent, and interest, which is usury and which goes against God's law, is extra money on top of that the person will receive. They both can vary, among other factors, by principal amount, interest rate, maturity, and the frequency by which the interest is compounded. Additional terms in a loan, for example, collateral, or what happens when the borrower defaults, may be negotiated in a lending agreement. So that collateral is the securitizing of the loan by putting your house up as collateral. That is called a mortgage. And since I mentioned that, I'll show you the case law where it states that a mortgage is a mere lien. It's not ownership of anything.
Right.
I should probably go to this other book that I have because it's highlighted. Where is it at? I'll also put it in the slide that I'm going to do. There's a lecture I'll be doing on this. Where is it at? Here it is. I feel like, how many times have we done videos on this?
A lot.
Because they don't have questions in the chat. I feel like the chat is just absolutely quiet.
I was going to say, who is that?
Here it is. Let's see. Where we at? Oh no, that's other stuff.
Excuse me.
Here we go. I'll do this. I'll do this. I'll do this. I'll do that. I'm giving it all away. Oh man. Unfortunately, I'm giving it all away.
It's a good deed.
Huh?
It's a good deed.
It is a good deed, but I like there to be suspense. Like, oh, people are suspenseful about what they're getting when they get it, as opposed to, oh, I know exactly what I'm getting.
You're not giving the whole thing away.
I know. Here we go. A mortgage is merely a lien and passes no title to the mortgaged property. And this also has to do with promissory fraud, because when you get mortgages, you think, you're under the impression, you're under the belief that you're going to become a homeowner. Right? So you're being deceived. Here's the case law. A mortgage cannot constitute color of title for purposes of acquiring title by adverse possession, as a mortgage does not purport to convey title to property. So it's not even a fake title. It's just not title at all. And then I define color, which most Moors know, distinguish from that which is real. Color of title, to one not skilled in law, the appearance, semblance, or simulacrum of title. A title that is imperfect, but not so obviously so that it would be apparent to one not skilled in law. So they're counting on your ignorance of law for you to believe that it's title to anything. That which is title in appearance, but not in reality. Another case, a mortgage is considered only a lien and therefore not a transfer of title. By modern law and under the statutes of many states, a mortgage is a mere lien upon land. The true meaning of the word fee is the same as that of feud or fief, and in its original sense is taken in contradistinction to allodiern, Black's Law Dictionary. The word fee was originally used in contradistinction to allodium, and then a case. And then the link. A mortgage property is considered fee simple. So if fee is in contrast to allodium, well, then you definitely will never own title by a mortgage. You'll never own anything in allodium by a mortgage. And then this is who these people are, because I have, I'm using them as a source, so I'm showing who they are. Another case, U.S. Supreme Court. Imagine that. In fee simple by way of mortgage. So a mortgage is what? Fee simple. Deed. I just define a deed, how a deed is not ownership. Huh?
What's a fee simple?
Fee simple is the highest form of land ownership in a feudal system. So whereas in England the king is sovereign, only the king can have a allodial title to land. And then under him are his lords, the knights and the banks and the rich people. And they can have people as vassals, and the higher, meaning those people will come to their courts whenever they command them to. Those people will serve in their military whenever they command them to. And in compensation for their homage and fealty, for their loyalty and fighting for them, they get to live on this piece of property, and then they get to pass it down to their children, so long as they have homage and fealty to this lord or his family, or the knight and his family. And that's called sub-infeudation. So remember in the movie with Jamie Foxx, Robin Hood, where Lord Loxley went off to fight in the Crusade, and then the sheriff of Nottingham said he was dead and took his estate? Because he's the Lord, he can do that. That's feudal tenures. A mortgage shall mean a first mortgage on real estate in fee simple. A mortgage is merely a lien and passes no title to mortgage property. The mortgage, both on its face and under the law, only gives the mortgagee the right to enforce the lien by foreclosing on the property. A mortgage, therefore, does not purport to convey title to the property and cannot constitute color of title. So when in definition, in defining what a loan was from Cornell University, we see that there are oftentimes things put up as collateral for that loan. So when you sign a mortgage, that's all you're doing. You're saying, I want a loan, and then I'm going to make payments on that loan. And if I don't make payments on that loan, here's my property as collateral. But remember, it's not your property. So the whole thing is fake. Where are we? What else? Okay, so now, if I were to receive, this is all hypothetical. Like I said, this is all. The creation of a straw man was for lawyers and attorneys to practice defending someone, and as opposed to dealing with real life issues, they would have a fake person called a straw man, and they would be the defendant and the plaintiff. So this is a straw man argument, meaning we're not being foreclosed on. this is just, we're playing court right now, right? So we're playing court as if a bank sent us that notice that I read earlier that they have this interest in this alleged loan that they borrowed, that they gave us, and now they're bringing us to court. And like I said, like it says at the top, this is not legal advice, but just speaking hypothetically. So I'm gonna in this fake scenario, I'm gonna pretend that it's real. So I'm gonna say things like I would say this and I would do that, but it's not real. Obviously, we're in my little office, so it's not real. Right, full disclosure. So knowing that in a foreclosure, at least in Rhode Island, there's laws that say I have the right to arbitration before we even go to court. So we're gonna pretend we're not in Rhode Island. We're gonna pretend this is just. We're gonna pretend that doesn't exist because that's not in every state. So, but we do know that if a bank is gonna, or any mortgage lender, whatever, is gonna file a claim, it's gonna go to court. They're gonna file a claim in court. We're gonna get a notice to appear. We're gonna get a notice that someone's saying something against us. We're gonna show up to court, and they're gonna give us a copy of what the bank is alleging. Then the bank is probably gonna give a scheduling of when discovery is going to be given, a deadline for, they're going to propose it, a deadline for all motions, when deposition is going to be, when, etc., 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 etc. Right? So they're going to give, what's that called, a flow chart of things to come. So when you, dealing with the Constitution, you have the right to face your accuser, so they're accusing you things. That's what the deposition is. So let's just Google search what a deposition is. All right, we're going to read that on Google. DEPOSITION, deposition. Deposition, an action of deposing someone, especially a monarch. In law, the process of giving sworn evidence, the deposition of 4 expert witnesses. So, here's another one. A deposition in law of the United States, or examination for discovery in the law of Canada, involves the taking of sworn out-of-court oral testimony of a witness that may be reduced to a written transcript for later use in court or for discovery purposes. So, let's say there isn't a deposition yet, but I want to do, let's say, a motion to compel discovery. I like how I spell compel. It's very good. A motion to compel discovery, and I'll probably make it all caps. And it would say things like Bank of Thieves versus Moors. So that would probably be, the title of the case, Bank of Thieves versus, because they are thieves, versus whoever. And then I'll probably put, case number. Right? Motion to compel discovery. How would I say this? I would probably say, I'll probably do let me see, there's going to have to be a memorandum, which that's what all these laws are for, so I'll just do that. Memorandum of law, since it's already here. You thought you could read my mind, huh, computer? You can't. Make sure this is, I'll do this. I mean, it doesn't really matter. This isn't a final thing. This is just an example of hypothetically what I would do. Memorandum of law, affidavit of fact. Here now. Here now. Jeez. Comes the defendant. You see my spelling is so good?
Mm-hmm.
Jamal.
Yeah, you spelled your name really well, too.
To assert these facts to the best of my ability. Stop laughing at me. To the best of my ability. Without malice. And to look at that. Pursuant to the Constitution. Look at that. Compel the alleged creditor / loaning agent to provide the following information regarding the alleged loan number, whatever the bank's loan account is saying that you have entered. Period. The alleged creditor claims that a mortgage, a promissory note was entered into on this date.
I like the way you type. Your 3 fingers that you use must be really strong.
And alleges that to secure the loan, a lien by way of mortgage was placed on my estate of 123 Friendship Street, Clownsville, Looney Town. Plot number 777, because more's like sevens. Plot number 777 in the county of. Spell street wrong. Jeez. Clownsville, spelled that right. Looney Town, spelled that right. In a county of deceit. Pursuant to United States federal law, this debt must in order for me to be held liable, for this alleged debt, the creditor.
Say it out loud. Oh, I guess you have to for the camera.
Yeah, the creditor must first prove the debt is real and prove that advances were made on the principal amount to prove evidence, look at that, of indebtedness. Oh, look at that. Spell them out wrong. Okay, so let's recap. I spelled deceit correct. You're reading with your lower self. Here now comes the defendant, Jamal, to assert these facts to the best of my ability without malice and to, pursuant to the Constitution, compel the alleged creditor / loaning agent to provide the following information regarding the alleged loan number blank 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 blank. The alleged creditor claims that a promissory note was entered into on this date and alleges that to secure the loan, a lien by way of mortgage was placed on my estate of 123 Friendship Street, Clownsville, Looneytown, plot number 77 in the county of Deceit. Pursuant to United States federal law, in order for me to be held liable for this alleged debt, the creditor must first prove the debt is real and prove that advances were made on the principal amount to prove evidence of indebtedness. How does that sound? In the nature of discovery, I request this court to demand that the alleged creditor submit and creditor answer the following questions and provide the following information with regard to the documents requested, requested, requested. The defense requests certified copies or the original wet ink signed documents. Discovery, Discovery, discovery demands. And so for these discovery demands, hypothetically in this fake scenario that is not real, if I don't do a motion to compel discovery and deposition is scheduled where there's a stenographer, I would probably still write some of these questions out just to be prepared for the deposition and ask the bank some of these questions. And I'm just going to copy and paste some of the information that's in here in the debt, in the financial literacy, debt validation letter, cease and desist, notice of intent to sue upon failure to validate the debt. I'm just going to copy and paste what's already written because I already did the work. And then we'll read it by line item. Let's go to it. Should I do this? Excuse me. This is.
Should keep some stuff.
I mean, hey. Yeah, we'll just do this one. Just these things. Just all of this. And hopefully, you know, we will be rewarded by Allah for our good deeds. Discovery demands. Name and address of the alleged creditor, which most of the time, once you get served in court, you'll probably already get this. They'll probably send you the mortgage and all that. They were probably already going to send you this information. So most information is not even needed. Like this, the alleged account number. Obviously, I put it up here, so I wouldn't need that. I already know who I'm talking to because we're in court. I already know the amount. Date this alleged amount became payable. That is important. Clarify in writing if the amount transferred into the account of the alleged debtor was made in lawful money or promissory notes. That is good. Date of original charge of delinquency. That is good to make, let me know if you even notified me if I was in default. Was this debt assigned to a debt collector or was it purchased? Meaning, people, Fannie Mae and Freddie Mac, the secondary mortgage market, which most of the time when they sell your debt, on the secondary market, you'll get a notification. But if you haven't, either way. Amount paid if debt was purchased, meaning how much did you sell my debt for? I want to know that.
Mm-hmm.
Because if we're dealing with equity, that means that amount should be taken from the principal. Doesn't seem fair to me. Clarify.
Money.
Exactly. Because what happens is the bank never loaned you anything. They never gave you any money. You made a down payment, which means they received money. Mm-hmm. Then you made payments for a year, which means they received more money. And then they sold the debt to someone else, which means they received more money without even giving you anything. Just for someone else to say, oh, now you make monthly payments to me. When they gave, so, well, then subtract that amount that you gave to the bank from the original loan, which, these criminals won't do. Clarify in writing which laws, if any, govern the alleged loan or promissory agreement. Read your mortgage, because that's in there. So we'll get rid of that. Produce a certified copy of the original note or promissory note consisting of the wet ink signature of both the debtor and creditor. That is good, so we'll subtract this, because that's already there. Clarify whether or not you or your agency is asking for gold or silver coin as payment of its alleged debt or private commercial paper Federal Reserve notes. Now, this is very important because of the Uniform Commercial Code, which specifies that if you make a counteroffer of anything of value and they deny it, then the debt's considered discharged. So that's good for you. Number 8, banking transactions or a check from the lender/creditor with the borrower's receipt of the face amount of the note. Or increments. I spell increments. Increments of the principal received. Wow. Jeez, I'm butchering spelling. Increments. I don't care. What matters is,
right,
is it working? Which it has worked. And just oh, I can't show it. I don't have it set up. Who cares? Go to my website. You'll see stuff worked.
Excuse me.
Attach copies of the following. Agreement with your client that grants whatever collecting agency has the authority to collect this debt. Signed agreement debtor has made with debt collector or other verifiable proof debtor has a contractual obligation to pay the debt collector. Any agreement that bears the signature of debtor wherein they agreed to pay the creditor. All statements while this account was open. Banking transactions or a check from the lender/creditor with the borrower's receipt of the face amount of the note. So that's kind of repeating itself. Where is that already at? That's up here somewhere, right?
Kind of, I think. No.
Yeah, right here. Banking transaction or a check from the lender/creditor with the borrower's receipt of the face amount of the note. That's already there.
I think this one had a little more detail now. No, I guess it's kind of the same.
Yes,
no, I was saying I think it's a little bit more detailed, but it might just be.
Nah, this one I made it more detailed. It was the same exact thing. All statements, blah blah blah. Whether or not the amount in dispute is insured by a state or federal agency. Do we understand the importance of that? And if you don't, I'm going to explain to you. If a bank loans you $200,000 mortgage, they're insured up to $250,000. Which means if you don't pay that $200,000, they don't even receive a loss. The federal government's going to give them that. And then pursuant to the fractional banking policy of the United States banks, they don't even have to have the full $200,000. They only are required to have $20,000 in cash. Then they never loaned you anything. You made a down payment. Then you made monthly payments. Then they sold the mortgage. And they can just say, you defaulted and get $250,000 of insured money. So they can get a 500% profit. Go ahead.
No, and then I was going to say then they just go and sell. Sometimes they sell it for a very, very small amount.
Yeah, like a tax lien or
you offer this small
exactly
amount?
As a settlement to cure the debt, because in most mortgage contracts it doesn't say you're required to pay, it just says you're required to cure it, which is not paying. If you are my wife and I say, all right, you owe me $5, which just wouldn't happen. You haven't paid me in 7 years. Just give me $1 for now. That's curing it. That's curing my my insecurity of you not paying me. Just give me $1. Okay, now you only owe me $4. You know what I'm saying? So that's very important. Whether or not a claim was made by said insurance agency, and if the alleged creditor has received payments by said insurance agency. So this is asking, did the bank already account or make this count? Did the bank already claim that this account was a loss, and have they already received the federally insured money? And that's called FDIC, right?
Mm-hmm.
The Federal Debt Insurance.
But it is FDIC.
Let's look it up, just so it's pretty informative.
What time do you think?
What's that? Oh, it's up to you. Why is she asking?
Well, no, they're just having lunch now, so I figured.
FDIC is Federal Deposit Insurance Corporation. That's what it is. And I'll just read some of it. This is from Investopia. The Federal Deposit Insurance Corporation is an independent federal agency insuring deposits of U.S. banks and thrifts in the event of bank failures. So when the market crashed in 2008, the banks received zero loss. Why? Because they had insurance. And then you'll see in the description of this video, actually it might be in one of these books, where certain banks like Deutsche Bank and Wells Fargo had to pay $1 billion or $1 trillion because they had admitted fault in creating the 2008 market crash. Now, as a result of that market crash, people lost their houses. Mm-hmm. So if the bank is saying that they played a role in that, what should that mean? That those people should get their properties back. Because it wasn't their fault that they defaulted. It was the bank's fault for crashing the market and plummeting the value and plummeting how much money people were receiving and giving out faulty loans. So this issue is a lot bigger than just one person's claim. Anyway. If the debt was sold, how much was it sold for, along with proof of sale and the contract information of the seller and buyer. This is also what I would probably add if we're having, what's it called? The deposition. In the specify, specify whether, is it W-I or W-E? Whether or not.
No.
It's not that one, it's W-E?
Okay.
Whether?
Yeah.
Weather. Is weather?
And then weather.
And then weather.
Yeah.
And weather are both spelled the same, right?
W-H.
Oh.
Yeah.
No E.
Yep. And then take that.
It's terrible.
It's okay.
It says it's spelled right. W-E-T. Yeah, weather.
Okay.
And not weather, like outside.
No, I know that. But this doesn't look right to me. I think that.
So what is it? W-H-E?
No, yeah, it is right. Yeah.
A?
No,
T-H-E-R?
no, you have it right.
Yeah, and then the other weather is this.
Yeah.
Yeah, okay. All right. Specify whether or not the creditor, it's credit, C-R-E-D-I-T-R, creditor, I put an F. Whether or not the creditor promised in the promissory note I butchered that. I always mess up promissory. I butchered it. I messed it up again. There is one M. How did I spell it? Who cares? Specify whether or not the creditor promised in the promissory note to lend any money. Specify whether or not how much of the principal amount promised to be lent by the creditor was actually given to the alleged debtor. Right, so let's say we're at the deposition, right? And let's say sorry, but you're the bank, and I'm the alleged debtor.
Mm-hmm.
There's a stenographer typing everything we're saying, and your attorney's there, my attorney's there, whatever I have attorney is going to be me. I'm probably going to say, and what's your name? Because it's being typed up, and you'll say,
Fraudulent bank.
Good morning, Mr. Fraudulent Bank. We are here today to discuss the loan number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Is that correct?
Yes.
And you represent the Fraudulent Bank Incorporated. Or what's it called? Bank of Thieves. Is that correct?
Correct.
And how long have you been working there?
About 25 years.
Okay. And this is dealing with that alleged loan number, and it appears that my name is listed as the debtor. Is that correct?
Yes.
So, in this promissory agreement, does it state that the bank is going to lend me a certain sum of money? And in exchange for that certain sum of money, I will make monthly payments plus interest?
Correct.
And how much was the loan amount?
$500 million.
$500 million. And is it true that after the promissory note was signed, this loan or this note was securitized to give some type of security to the bank? Because obviously that's a large amount of money. So is it true that a house was put up as collateral if payments weren't made on that loan?
Correct.
Okay, so in this promissory note, it is clear that you're claiming that I agreed to pay monthly payments of this $500 million, correct?
Yes.
But also in the note, doesn't it state that it's the bank's promise to lend me $500 million? Is that correct?
More or less.
What do you mean by more or less? Does the paper say that the Bank of Thieves is going to lend $500 million to me? Is that what the document says?
Yes.
Okay. So the document does say that the bank was going to lend $500 million to me. Okay. Do you know when the bank sent any of that money?
No.
You don't know. So you're not aware that in this promissory note that the bank did what they promised they were going to do. So you're not sure if the bank fulfilled their duty in this promise.
I can't confirm or deny that.
You can't confirm or deny that. Do you know if the bank has any transactions proving that they made any advance of this $500 million to my bank account?
No, we cannot.
You can't prove that. So how is it that you're claiming that I owe the bank anything then? If you can't prove that, if you're saying that I didn't make any payments on this $500 million loan, but you're saying you can't prove that you actually lent me anything, how can you possibly say that I never paid you anything? And you don't have to answer that because I put you under the fire. But this is an example of what the power people have as the alleged borrower to put them under the fire, to ask them. So this is the note. This is the promissory note. Well, yeah, this is what we filed with the court. It says you owe this amount of money. Mm-hmm. Okay, but doesn't it also say in the promissory note that you're going to give me money? Well, yeah, of course. Do you have proof that you actually gave me anything? The answer is no. All right, so if, hypothetically we were in that situation where there's a deposition, that's some of the things that we would ask, right? And then obviously anything else that, we'll put you, what was your name again?
Fraudulent bank.
Fraudulent bank. We'll put fraudulent bank back on the stand. Was this loan sold on the secondary market? And it could either be, the bank you represent brought it from another bank,
mm-hmm.
or you're the bank that sold it to someone else, and you're not telling me that it was sold. So you can answer however you want.
Yes.
It was sold. And who was it sold to? Who was the mortgage-backed security sold to?
The swiper of souls.
Okay, so in this particular case,
LLC.
This bank is saying that the promissory note that I have with the Bank of Thieves, who you represent, was sold to who? The stealer of souls?
The swiper of souls.
The swiper of souls LLC. Yeah. So then that would mean that the bank you represent isn't the holder in due course of this loan.
I guess you can say that.
Okay, no more further questions. So if that's how the deposition ends, I would promptly draft up a motion to dismiss for failure to make a claim upon which relief may be granted, because the plaintiff isn't even the holder in due course of this alleged debt.
They have to prove how they had ownership of the home if banks cannot be the holder in due course.
Well,
of
ownership
the home.
of the loan. Ownership of the loan, of the promissory note. Because the house isn't in question, the loan is in question. So the Soul Swipers LLC would have to prove, or the Bank of Thieves would have to prove that they're holder in due course. Now that's not here, but let me look it up. Let's look it up together. Google search holder. What's that? Holder of due course. Holder of due course is defined by Google as, in commercial law, a holder in due course is someone who takes a negotiable instrument in a value for value exchange without reason to doubt that the instrument will be paid. Which just means it's someone who actually has the note. Since I have it, I'm the holder in due course. Since I'm the holder in due course, or since I have the note, I can say you owe me. If I don't have it, then that means I'm not the holder in due course, and I cannot say you owe me. So not only do I have to be the holder in due course, I have to validate the instrument that I have to prove that I'm the holder in due course. Because let's say, Bank of Thieves and Soul Swiper LLC are both trying to foreclose on this house. Well, then who actually owns it? Who actually is the holder in due course of the loan, right? And that's actually something that my mother's going through, where there's a lot of fraudulent shit going on with the house. Yeah, exactly. No, it's him. No, it's me. No, it's you. No, it's them, right? Fraud. Just a bunch of fraud. So that's an example of what can be done very briefly. So after this specific hypothetical situation where we've just found out that the Bank of Thieves is not the holder in due course, and that the Soul Swipers LLC is the holder in due course, then we'll file for a motion to dismiss, and we'll attach some of the transcript of the deposition to the motion. In the alternative, if you didn't say Swipers of Souls LLC purchased the note, the mortgage-backed security, and that the Bank of Thieves is the actual holder in due course, they still have the note, then I would still file for a motion to dismiss, because in your own testimony, your own deposition, your own sworn deposition, you stated that the bank promised to loan me the $500 million and never gave it to me. Right? So a motion to dismiss will be sent because of that as well. And then that gives me standing to sue. Right? So
we give you credit of $500 million.
Yeah, so show me the credit. Show me the line of credit. Cause look, remember. Let's look. Right? Because what'd you say? Say that one more time.
That you gave me, we gave you the $500 million in credit.
The mere existence of this line of credit agreement does not support a presumption that the full amount of the line was ever advanced. That's what the memorandum of law is for, sir. For your effery. Now, also people will say, well, you did receive something. You received the house. That's what people will say. So let's go back to the deposition. Let's go back to the question where I asked, did you loan me the $500 million? And your response would be,
yes.
No. Your response would be, we gave you the house.
Right.
So, Mr. What's your name again?
Fraudulent bank.
Mr. Fraudulent Banker.
Yes.
Who represents the Bank of Thieves.
Right.
The attorney of record. In the promissory note, you admitted that the Bank of Thieves, who you represent, was going to loan me the $500 million. Did you give me that?
No.
What did you give me?
A home.
You gave me the home. Where in the promissory note does it say that you're going to give me a home? It doesn't, does it? I don't know what I'm doing. I only worked here for 25 years. So,
line 25.
Line 25. So for the viewers, if your family has a mortgage, if you have a mortgage, read it, and you will never see on any mortgage where the bank says, I'm giving you this home. Mm-hmm. They don't say that because they can't. They're giving loans, right? So for the people that say that, well, they gave you a home. No, they didn't. Mm-hmm. What was supposed to happen was they gave you money. You purchased the home with your money.
Right, because they can't own the home.
Exactly, and then you put your house that you just purchased up as collateral. That's what the promissory note is, and that's what the mortgage is. Them giving you money to buy a home, you actually buying the home, and then you putting up your house as collateral, which that's the mortgage part. So there is no valid argument according to the four corner rules of the promissory note that, well, they gave you a house, but that's not what they promised at all. So now, right, the deposition is over, and that's where I have here, right here, the notice of intent to sue upon failure to validate the debt.
Wouldn't they?
Go ahead.
Wouldn't they give, just for the viewers, a question that they might have, wouldn't they give the seller, like the person who's privately selling the home, the money, and that person gives you the home?
Is that what the promissory note says? Because look, if we write down on paper that I'm going to paint your house for $500 and I'm going to paint it green, if I paint your house red, did I violate the terms of that contract? Mm-hmm. Yes, I did. Because it didn't say red, it said green. Mm-hmm. So it doesn't matter what you did. What matters is, did you do what you said you were going to do? Because that's what the bank is saying. Mm-hmm. You said you were going to pay this amount of money plus interest. You didn't. And since you didn't, part of the agreement is when you don't, I get your house. Mm-hmm. Well, Mr. Bank of Thieves, you promised to give me money in the first place. So, like this court said, show me the evidence that any advancement on the face of the principal amount of the note was given to me. Right. For me to even owe you anything. Show me, prove it to me. Show me the receipt. Show me the borrower's receipt, because that would prove that I'm in debt to you. Mm-hmm. You just saying it's a presumption, right? Where's it at? It's just a presumption. So now I have to either prove, right? So the burden shifts on me now. So the Bank of Thieves is saying that you gave me $500 million. Mm-hmm. That's what you're saying. That's a presumption. So now the burden shifts on me. Well, Mr. Bank, I paid you this amount. Or in the latter case, well, you never gave me anything. So the burden shifts on me to either, right? This is what the court said. The burden then shifts to the borrower, which would be me, to rebut the presumption that you loaned me anything by either proving that I made payments on that loan or by proving that the face amount of the note was never advanced, meaning you never gave me diddly squat. Mm-hmm. So now the burden shifts on me, which means I get to ask you, show me the banking transactions where you sent me any money. Yeah, exactly. And that's what this case law is for. The mere existence of the line of credit, meaning the promissory note with a number on it, that's just simple existence, doesn't support the presumption that that amount was actually given to me. Only the receipt of that would. Mm-hmm. Is everyone following on that? Right, right? Again, the notice of intent to sue upon failure to validate the debt. Now we're at this point because the Bank of Thieves did not prove that they lent me anything. right? So now, and I'm not going to type this up. I'm just going to read some of the case law that I have in the books. Right? I'm gonna attach this to my notice of intent to sue, which I have the template in the book, so I'm not gonna redo it like I did the other thing. So here's an example of case law that I would use against the Bank of Thieves and Swiper of Souls LLC and fraudulent banker attorney at law. Promissory fraud, a subspecies of fraud and deceit. A promise to do something necessarily implies the intent to perform. Hence, where a promise is made without such intention, there is an implied misrepresentation of fact that may be actionable fraud. So you promised to give me money and you had no intentions on doing it. That's promissory fraud. What else we got here? Inshallah, this will reach who it needs to reach. One is liable for fraudulent deceit if he deceives another with intent to induce him to alter his position to his injury or risk. To induce him to alter his position to his injury or risk. Boom. Deceit for the purposes of this blah, 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 blah is a promise made without any intent of performing it. Now, right? So in the description of this video on YouTube, there's several links from the United States Justice Department that shows, as an example, Deutsche Bank pays this amount of money for fraud. Deutsche Bank pays this amount of money for embezzlement, for misleading, da da da. So they have a history of it. So based on this history and based on the fact that you never transferred me anything, this proves that you never had intent to transfer me anything. Now here's some of the elements that I would have to prove. The elements of fraud, which give rise to the tort action for deceit, are misrepresentation, false representation, concealment, or non-disclosure. So I was told I'm owning a house with a mortgage, but the law, that's why I read, mortgage does not convey title to property. So I was deceived. I was told in order to be I'm a first-time homeowner. That's what I was told. In order to do that, I have to get a mortgage. So you're deceived. So that's an element you have to prove, right? Knowledge of falsity. So you knew a mortgage wasn't ownership of land or property, and you said it was. You knew you wasn't going to loan me anything, and you said you were. What else? Intent to defraud. You knew. Resulting in damage. I paid you a down payment and made monthly payments for 5 years, 10 years, 2 years. You received something from me and I received nothing. I lost. Those are the damages. Right? Justifiable reliance. I assumed, right, to induce reliance. Well, you signed the contract. You made me sign a contract.
You say out loud.
Right? Justifiable reliance. I'm relying on this contract that we made. I'm justified to rely on this because you're actually charging me with violating it. What else? Inshallah, this will help people. Inshallah, we can make a change. We'll just read these right here. We'll stop right there. I'm loud because I'm passionate, because people are being screwed over.
Mm-hmm.
That's why I'm loud. Where do we stop at?
Sorry, you put on music to drown you out.
A promise of future conduct is actionable as fraud only if made without a present intent to perform. So now if you're in court and you say, well, bank, you never gave me the $500 million. If the bank does not intend to give you the $500 million from that point forward, then guess what? You have standing for fraud. A declaration of intent, although in the nature of a promise made in good faith, without intent to deceive, and in the honest expectation that it will be fulfilled, even though it is not carried out, does not constitute a fraud. Okay, so now that I'm saying that I was never loaned to $500 million, now give it to me. Okay, so then you never had intent. Moreover, something more than non-performance is required to prove the defendant's intent not to perform his promise. If plaintiff adduces no further evidence of fraudulent intent than proof of non-performance of an oral promise, he will never reach a jury. So this is just a warning to people that you have to have more than a claim, you have to have evidence. And having the track record of these banks constantly having to pay fines and fees for fraud and deceit is proof that they always had this intent because they've been found guilty before. Fraudulent lending. Anyway, in a promissory fraud action, to sufficiently allege defendant made a misrepresentation, the complaint must allege 1. The defendant made a representation of intent to perform some future action, i.e. the defendant made a promise, which is exactly what the promissory note is. They promised to give you money. 2. The defendant did not really have the intent at the time that promise was made, i.e. the promise was false. Well, clearly they didn't have the intent to pay me because they never gave me anything. 4, 5, 6, 7, 8, 9, 10 years later, still haven't received $1 from the bank of this alleged loan that I signed for. Action for promissory fraud may lie where a defendant fraudulently induces the plaintiff to enter into a written contract. In such cases, the plaintiff's claim does not depend upon whether the defendant's promise is ultimately enforceable as a contract. So, let me read that again. So, promissory fraud may lie where a defendant fraudulently. So, this is the defendant in this case would be the bank, and you would be the plaintiff because you're charging for fraud. And they induced you into a contract, meaning the promissory note. In such cases, the plaintiff, meaning me, my claim does not depend upon whether the defendant's promise is ultimately enforceable as a contract. Because they'll say, well, only you signed it, not us. This is saying that doesn't matter. Because you're trying to enforce it against them. Which means you're claiming to be a party. You know what I'm saying? Fraud may encourage attempts to convert contractual disputes into litigation over alleged fraud. To be sure,
I'm just reading
along. To be sure, fraud requires proof of the additional elements of intent and reliance. But these can so easily be inferred from any broken promise that promissory fraud may in fact open the doors to attempt to enforce oral promises through tort cases of action under the guise of a promise made without intent to perform. So this just tells you that this opens a can of worms for these people. In the leading case of this case, the court reasoned that plaintiff's cause of action for fraud is not for the collection of compensation for the performance of any act or contract for which a license is required. Plaintiff's right is the outgrowth of the deceit practiced upon him by the defendants. The validity or invalidity of his contracts does not affect that right. Proof of the contract under the cause of action for fraud was merely proof of the circumstances under which the plaintiff's services were rendered and his money was expended. So that isn't really beneficial, but it's in there anyway just because I was looking up fraud and the potential to throw people's claims out is also something that you have to consider when you're trying to sue someone for fraud. Figure out what their arguments are. Someone said, wouldn't a check be a promissory note? Yes, it is. It's a promise to it's a negotiable instrument. So it when you sign it is a promise to pay a sum amount. So yes.
Unless it's like a bank check, right?
No, it's still an amount there's still an amount that someone that someone is going to receive. So it's still someone is promising to give somebody something.
Mm-hmm.
So yeah, it's still a promissory note. So my girl got a check for the house. So from what I'm reading, they signed up to pay a mortgage, but they never gave her mom to truly buy the house. Yeah, so let me read that case law on a check and a note. Where's it at? Where do I have that at? It might be in a different document. So for that situation, it's going to be a little tricky because although you didn't receive the actual money, somebody received money. You know what I'm saying? And in the promissory note, does it say that the bank promises to give it to you in the form of a check? Where's it at? I think it's in estate law. I have a whole trust law series where all of this is talked about. So I'm just trying to figure out where I have it. I think it's in estate law, which would be trust law 104, I think. But again, that raises even further questions because a check, they promise to give you money, not a check.
Mm-hmm.
They didn't say we'll give you the cash value or we'll give you the value of 200,000. They said we're going to give you 200,000. That was a great question. And then also there's this case law where it says, Federal Reserve notes are not money. That's Craig versus Missouri. Oh, this one's actually not Craig versus Missouri. This is United States Supreme Court legal tender case. But where is it? Let me see.
There's the Craig versus Missouri on the bottom.
Yeah. Do. A check payable in notes is an altered instrument and void. And I guess I'll read the Craig versus Missouri one. I'm not going to read the whole. This isn't a lot, right? Would you say this is a lot? Okay. Seeking the reward of Allah. All right, so Congress had no express authority to issue treasury notes. What is a bill of credit? What did the Constitution mean to forbid? In its enlarged and perhaps its literal sense, the term bill of credit may comprehend any instrument by which a state engages to pay money at a future day, thus including a certificate given for money borrowed or a promissory note. To emit bills of credit conveys to the mind the idea of issuing paper intended to circulate through the community for its ordinary purposes as money, which paper is redeemable at a future date, which is the same thing as a check. This is the sense in which the terms have been always understood. Such a medium has been always liable to considerable fluctuation. Its value is continually changing, and these changes, often great and sudden, expose individuals to immense loss, are the sources of ruinous speculations, and destroy all confidence between man and man. To cut up this mischief by the roots, a mischief which was felt through the United States, and which deeply affected the interest and prosperity of all, the people declared in their Constitution that no state shall emit bills of credit. If the prohibition means anything, if the words are not empty sounds, it must comprehend the emission of any paper medium. The history of paper money has been referred to for the purposes of showing that its great mischief consists in being made a tender, and that therefore the general words of the Constitution may be restrained to a particular intent. It has been long settled that a promise made in consideration of an act which is forbidden by law is void. So a check payable in notes is void because the note itself being made a legal tender is unconstitutional. It will not be questioned that an act forbidden by the Constitution of the United States, which is the supreme law, is against law. In reference to paper money as a circulating medium, that which it is not permitted to do directly cannot be legalized by any change of names or forms. Acts done in fraudum legis are acts in violation of the law. Like I said, all this information is available in my Trust Law series that has been available for years. Let's see. What else we got in the comments? Not many, which is surprising, very surprising. Because there's a lot of people in my DMs asking questions.
What is course, you can send them the video.
Yeah. What if they gave you a check? Okay, let's answer that. Okay, answer that. Yeah, First National Bank of Montgomery versus Jerome Daly dealt with this. What about credit cards? Credit card is simple. We'll go back down to Craig versus Missouri. So, with the question right here, First National Bank of Montgomery versus Jerome Daly, the judge declared that the mortgage was void because the consideration wasn't lawful, meaning the issuance of Federal Reserve notes as a loan was unlawful, which is exactly what this case is saying, Craig versus the state of Missouri, right here. It has long been settled that a promise made in consideration of an act which is forbidden by law is void, since the Constitution forbids the emission of bills of credit, which means it forbids the issuance of Federal Reserve notes as legal tender. Since that's unconstitutional, any contract made in consideration of that is void. So, to my knowledge, a credit card is essentially saying that the bank is going to issue a line of credit in their name and that you will pay them back in Federal Reserve notes. Since they're asking for Federal Reserve notes, that contract is void. And since they'll be paying all of the things you swipe in their, in the name of their card in Federal Reserve notes, it's also void. This is why Moore's, like Tashriq Bey referenced the Federal Reserve Act of 1913 and 1933 and the dissolution of the gold standard internationally in 1971 as so important because it violates the law. and here we are feeling the effects of this, right? So Craig versus the state of Missouri was a case in the 1800s, I'm pretty sure, late 1800s. What else we got here? What is this? 1830. And I don't feel like reading too much. I'm getting tired of reading. What else we have here? This one's even longer. The United States Supreme Court legal tender cases of 1870, number 43, decided December 1st, 1870. It explains how, like, as an example, Treasury notes have, as substance, no appreciable value. They are not declared to be and do not purport to be of any value as substance. They are not stamped with any intrinsic value. Like when you have a gold coin, it's stamped 0.99999 fine silver, or gold. That's the value. It's pure gold. They are not, so far as they possess value, things at all, but only things in action, meaning it's a promise that's never fulfilled. You can't even see what I'm reading because it's on a separate Word document. I'll just do this right here. Copy and paste that last paragraph that I'm reading. And then we'll wrap it up because I'm getting tired. This takes a lot of energy. Inshallah, I will be rewarded. They are not stamped with any intrinsic value. They are not, so far as they possess value, things at all, but only things in action. The material holds the evidence of the promise, but it is the promise and the promise alone which is and which purports to be of value. One dash of the pen across the signature of the Treasurer of the United States at their foot, and the note is not a treasury note, not a thing in action, not a matter which bears the government stamp of value, not $10 at all, but a worthless rag of paper, once used to hold a promise, now canceled. If therefore money, in the phrase to coin money, could be considered as embracing other substance beside those precious metals, alone in the use throughout all the world as coin, nonetheless would it remain that to utter promises to pay money would not be coining or to coin money. So USC 411 not authorized to use. Yeah, it's not. It's only to be made. So that Title 12, subsection 411 specifies that Federal Reserve notes are only to be made as advances for Federal Reserve banks. That's it. So it's from bank to bank. That's it, not people to people. But since the banks are the feudal lords and they made us their vassals, and we don't want to resist because we rather rap, go to more barbecues every year, and not schedule meetings with city and state officials to say, hey, look at the law. This needs to change. This is wrong. Then nothing will change. Anything else you think I should add before I wrap it up? Because I am tired.
I don't think so.
You can get these. You can get them at Rise of the Moors, riseofthemoors.org. We don't sell mixtapes. There's a rapper out there that's gonna be mad. They're available. All of this information has been made available is available. I mean, just look. You can go to justia.com and look up case law on promissory fraud. If you don't want to get anything from me, you don't have to. You don't have to spend your money with me. Go to justia.com. If you got the spare time, instead of going to the club, instead of going to the stew, I like how they say stew like it's cool. Instead of going to the studio, instead of going to the club, drinking, smoking, pick up your phone that's always in your hand anyway. Go to justia.com and look up promissory fraud. And you will see these cases because that's exactly what I did. And what you're exchanging is time, as opposed to you doing the research. I did the research, compiled it for you, and you'll be paying for your time. That's what you're paying for. I don't see any more questions. Do you have anything to add, Mrs. Fraudulent Banker?
No.
Is there anything you would add to this document? Any questions you think I missed to ask?
I'd have to look at it again to see, but
Jeez. All right. We'll wrap it up, I guess. Hopefully, well, let me go back up to the disclosure.
yeah, it's past my nap time.
Hopefully you learned something. Peace. We gotta wait a little bit because for some reason I have to wait like 5-10 seconds, or the audio just cuts me off. So that way.
Okay. It's like a little delay.
Yeah, but it's not a delay because it cuts me off. You know what I'm saying?
Mm.
It would be different. A delay would be I stop talking and then it's just me just not talking. Like if I say peace and then end it, I think like